It's safe to say that the VA can be quite confusing at times. This is especially true when it comes to the 1151 claim. From my experience, most veterans aren't aware of this type of claim, how they're even eligible, and how to file them. So today we're going to define the 1151 claim, discuss eligibility, and also give an example of what this type of claim entails. Title 38 U.S.C. Chapter 1151 allows the VA to pay compensation for death or disability as if service-connected. Under Section 1151, benefits may be paid for injuries incurred or aggravated while receiving VA-sponsored medical treatment, injuries incurred or aggravated while pursuing a course of vocational rehabilitation under 38 U.S.C. Chapter 31, or participating in compensated work therapy under 38 U.S.C. 1718 may also make you eligible. If eligibility is established under Section 1151, the disability is considered service-connected for payment purposes only, but that doesn't mean the disability is actually service-connected. So now that we know what an 1151 claim is, let's discuss who's eligible. First, the individual must be a veteran. The individual must have a disabling condition that is the result of or has been aggravated due to the VA-sponsored medical treatment or training. It's important to note that benefits will not be paid to veterans whose willful misconduct caused the injury or death. As a result of VA hospitalization, medical or surgical treatment, examination, or training, the evidence must show you have an additional disability or multiple disabilities, or an aggravation of an already existing injury or disease. And the disability was the direct result of VA fault such as carelessness, negligence, lack of proper skill, error in judgment, or not a reasonably expected result or complication of the VA care or treatment, or the direct result of participation in a VA vocational rehabilitation and employment or compensated work therapy program. A successful 1151 claim based on medical treatment should show that the injury or death was caused by one of the following. Again, we have negligence, carelessness, lack of proper skill, error in judgment, or any other fault, or an event that could not have been reasonably expected to occur with that type of treatment. This can still be a bit confusing, so let's better understand these claims by giving you an example. A veteran receiving treatment at a VA facility had an MRI performed. On the MRI, a large mass was noted, and though the VA intended to schedule additional testing for that veteran, they failed to schedule the appointments and the testing to follow up. So a few months later, the veteran asked his doctor about it, and that's when they realized the error, so they quickly scheduled an appointment. But unfortunately, the mass is now twice its size, it's cancerous, and it's inoperable because they failed to test it earlier. Due to the failure to schedule the follow-up testing, the veteran is now suffering from additional limitations, and the cancer has now spread. This is just one possible example of an 1151 claim, but I feel it'll help you better understand it. If you believe that you have an 1151 claim and you'd like a free consultation, call us today. Our toll-free number is 1-877-526-3457. Check us out online via our website at fightforvets.com, or you can check out our blog at veteransdisabilityblog.com.